Dr. Sri Nazri has called me a third-class lawyer. Well, I may be third class, but that man has got no class. Yesterday, when I announced that we intend to take this matter up in Parliament, rather in the courts, as to what has been in Parliament. Generally, of course, all these years, all proceedings in Parliament cannot be questioned in any court. But as a result of the Zamri case from Para, the Para court has decided that under certain circumstances, the decision of the Dewan Rakyat can be questioned in court. In fact, in the case of Singh, the principle was applied, and the court, in fact, took cognizance of the fact that Gobind was unlawfully, unconstitutionally deprived of his right to his privileges, and those were restored. So as far as we are concerned, this matter will go to court, there is a precedent, and we are serious about it. Now what transpired in the Committee of Privileges is something which cannot be defended. Now, the charge against me, for the purpose of my being admonished, was this, that I had insulted the chairman of the Privileges Committee, who of course is the Speaker of the Dewan Rakyat. In fact, on that ground alone, and that was made very clear to him, that his position as Speaker was untenable because of the charge against me, which involved, in fact, insulting. I don't run away from the fact that I had made certain remarks against him. Called him a dictator, that he was throwing tantrums, that he was indecisive, which in fact is quite demonstrated in the House itself. And I had every right to do that. But that's not so much the point. You cannot condemn someone without him or her being given an opportunity of being heard. I was not given that opportunity. Neither were the others. The other three who have also been suspended for 6 months, given that opportunity. It is elementary that an opportunity must be given. In fact, I quoted a Pakistani case, a case from Pakistan yesterday. In fact, audio train partner means both sides must be heard. In fact, it originated in Islamic jurisprudence. And the Supreme Court of Pakistan has said, in fact, the right to be heard is a command from the Quran itself. It originates in Islamic law, not so much the English law. English law adopted what is in Islamic jurisprudence. And what has happened, I think, is scandalous, unprecedented. And if we let things go as they are, let them slide, I think it will be something which we can't tolerate and we will not allow to happen. The action against the Speaker will be filed and will be filed very soon. As I said earlier, there has been a precedent. Speaker has been named as a respondent in Gobind's case. I'm surprised Nazri is coming up with a statement that the decision of the Dewan Rakyat cannot be questioned in court. And I'm giving it a matter of priority. In fact, during the weekend, I intend to sit down, draft up something, and then with the concurrence, of course, of Dr. Sri Shiva and the other lawyers, both in the DAP past and, of course, in the DAP rather, to get on with it. I think this is something which the public interest demands, and which we are going to give topmost priority.
Now, this is the minority report that Karpal has produced. It's available on several websites now, including the Sweet's website. And this is these are our views as the minority members of the committee on what happened. We have described here the flagrant breach of natural justice that happened, I think, which is very clear, starting from how the Speaker himself represented to the entire House on the 22nd of April, how he would make sure there was a proper inquiry. Witnesses would be called, the Member of Parliament involved, Dr. Sri himself, would be called. But, of course, on the 3rd of December, there was a complete about turn. Karpal and I protested, and they outvoted us, and then we said we would dissociate from those proceedings. So in our report, basically, what we have set out in detail, in much better detail, I must say, than the report produced yesterday, before the House. We've set out what took place in the first meeting on the 17th of May, what took place on the 8th and 9th of June, and finally the about turn that took place on the 3rd of December. Because on the 17th of May, first meeting, 8th and 9th June, second and third meetings, the committee was proceeding on the basis that witnesses would be called, that Dato' Anwar would be called to make his defense, and it was just a matter of fixing dates. But on the 3rd of December, this suddenly changed. Why? Because, there was this letter from APCO. And this is the power of the letter from APCO, that it can make the committee change direction completely, 180-degree turn. And what is interesting, as was pointed out, this letter from APCO itself contains a false statement, because the writer is saying, I was not permitted to testify, which is not true at all. And this is not the first time that APCO has made a public false statement. Prior to this, they denied publicly through a press statement any relationship with Israel, which immediately was contradicted the next day in the Straits Times, because the contract which the Dato' just mentioned was exposed. But the point is, APCO lied first in a press statement saying they have never done any previous work for Israel. So our argument in the committee was, why should you believe this letter? Why should you believe it? We want to cross-examine the maker of the letter. But the majority decided that that was not the way to proceed. They would just proceed on the documents. So it's interesting, Y.B. Karpal mentioned the right to be heard, enshrined in Islamic jurisprudence. We also mentioned in passing here, even God himself did not pass sentence upon Adam before he was called to make his defense. These principles are universally understood from a long time ago, but are now being just brushed aside by the BN brute majority in Parliament. Now, what the other point we make, just to summarize, is how the suspension of Dato' Anwar is a major threat, and including our other suspensions, to freedom of speech in Parliament. When Dato' Anwar made his comments about APCO, he had enough factual basis, which he pointed out in his speech. And that is the right accorded to any member of Parliament in Parliament, in any Parliament around the world, especially the House of Commons. There was a factual basis, and by no means can he be said to have misled the Parliament. In other words, there is a fundamental misunderstanding about what misleading Parliament is about. That when you mislead Parliament, you must stand up and say something that you know to be false. And in this situation, there's no question of that happening at all. So basically, what Barisan Nasional has done by the suspension yesterday, it has damaged the integrity, the dignity of Parliament, and it has severely threatened the basic freedom of speech, which is guaranteed to members of Parliament. Without that freedom of speech, we cannot do our job. Yesterday, we saw major damage to that fundamental principle, and it shows that Parliament itself now, as an institution, is under serious threat. So we invite members of the press to have a close look at this report, to write about it, because the Malaysian public needs to know the other side of the story, which has not been allowed to be told in our Parliament. And copies are available for members of the press who want to take away a hard copy. Now, finally, I'll go to the... Thank you, that's the point. We asked officially to the Speaker by letter dated 14th of December that this report by us, by the minority members, be tabled to every member of Parliament. The Speaker rejected this request on Wednesday, the next day. So, in other words, we were prevented from distributing it officially, but what we've done is we've given it, of course, to the Pakatan Rakyat MPs, and copies are available now publicly for all other members of Parliament. But this is another, of course, they are relying on technicalities like the standing orders to reject. But as far as we are concerned, I mean, why should we be afraid of allowing the minority views as well to go on the table together with their report? This was the official report presented, but we were prevented from placing this report on the tables of all MPs, in others, including the Barisan Nasional MPs. Now, just finally on the suspension, the motion which was used to suspend Karpal, myself, and Azmi. The accusation against us is that we breached Standing Order 85. And as far as I can see, it's very clear that's a completely false accusation. It's a false accusation because it distorts completely what Standing Order 85 says. Standing Order 85, Standing Order 85 says that a member of the committee and any other member, any other person cannot publish, the word is publish, menyiarkan in bahasa, cannot publish any evidence taken before the committee or any document given to the committee. Now the question of evidence taken does not arise because we have not even started taking evidence. We have not called any witness yet. Now, insofar as document is concerned, they are trying to say that by mentioning the letter from APCO, we have therefore breached Standing Order 85. Now, that is not what the Standing Order says. It does not say that we cannot mention the letter. We had a press conference on the 3rd of December after the committee decided to proceed without calling up the street, without calling any witnesses. As far as we were concerned, that's a gross violation of natural justice, and we are duty-bound as members of the committee and parliamentarians to inform the public. In fact, we would be in breach of our duty if we failed to do so, if we kept it a secret. And this is the press conference we had. And there can be no question of us breaching the standing order because the standing order is very clear. The motion to suspend uses the word menyentuh. But there's nothing about menyentuh in the standing order. The standing order says you cannot publish it. We did not distribute the letter. We did not read the contents out. We mentioned the fact of the letter because the fact of the letter has to be mentioned to explain our position. Because the committee decided to not call witnesses based on the letter. We have to explain that to the media, to all of you. And this has now been used in a gross abuse of power. I mean, by having this motion, by saying that we could not even mention the fact of the letter. This is the power of APCO, that their letters are top secret. We can't even mention it in public. And this is what is used to suspend all of us. Likewise, YB Asmin was very clear. He complied with Standing Order 85 all the way. He did not disclose the contents. He did not read the contents of the letter. His motion doesn't even mention the letter. And yet, all of us has been suspended on this false accusation that we have breached Standing Order 85.